My name is Farnaz Thompson, and I am the chair of McGuireWoods' education industry team. We have a deep bench of attorneys who are well-versed in education laws. We have a national education practice with 21 offices and over 900 attorneys, and it's my pleasure to introduce Heidi Siegmund and Daniel Masakayan, who will be leading the webinar today. Heidi is a member of our Labor and Employment Department, and her practice focuses on a wide range of education and employment-related issues. Heidi regularly defends educational institutions and other employers facing litigation in both federal and state court. She also counsels public and private schools on compliance with various federal and state employment laws and regulations. In addition, Heidi advises schools on a variety of issues outside the employment context, including Title IX, FERPA, and privacy issues, government investigations, contract negotiation and management, and parent and student conduct matters. Daniel Masakayan is an employment and education attorney, and his practice also focuses on K-12 institutions. He regularly serves as outside counsel to school boards, school divisions, school superintendents, as well as private schools. He represents schools in litigation, due process hearings, and investigations by state and federal agencies. He specializes in helping educational entities navigate personnel, policy, and employment issues. And although this webinar is dedicated to K-12 issues, it really is, for the most part, translatable across the realm to higher education as well when it comes to employment law issues. And it's my pleasure to introduce Heidi. Thank you, Heidi.
Thank you so much, Farnaz, and thank you to all of you for joining us this afternoon. We are going to cover the 4 topics that are up on your screen right now. I'm going to start by talking a little bit about internal investigations of employee complaints. Daniel will talk about best practices for performance management and for termination. And then I'll come back and talk a little bit about workplace accommodation requests under the ADA and a little bit of the interplay between that statute and the Family Medical Leave Act and workers' compensation laws as well. So any one of these topics could easily be an hour. So we'll try to just hit the high points and give everyone a few takeaways and a few things to think about as to each of these topics. So I'm going to start by talking about internal investigations. And just to make sure to set the stage a little bit for what we are and are not talking about here, obviously Title IX has its own procedural requirements. Some of the principles that I'm going to talk about will apply in Title IX investigations, but there will also be a number of additional requirements. We're happy to help with those, but that's not what we're specifically focused on here. So I'm going to be talking about just some things to issue spot at a high level in terms of processing, analyzing, and investigating employee complaints. So the first thing to do when you receive an employee complaint is to plan out your investigation. And I've got sort of 5 high-level steps for planning here. The first step is to determine what the issues are and what is the scope of the complaint. So is this complaint alleging a violation of law, either a civil law like anti-discrimination laws? Is it a potential criminal violation, or is this complaint alleging a violation of company policy? Those kinds of complaints are going to be your highest priority. You may also receive complaints that are more just sort of personality conflict kind of complaints that are, there's not enough, K-cups in the coffee machine, that sort of thing. Those kinds of complaints will be, still good to close out, but less important than complaints alleging violations of law or violations of policy. A few questions to be thinking about when you're taking this first step. Are there any mandatory reporting obligations? Obviously, schools have a duty to report any suspected abuse or neglect. In Virginia, most of the other states that we work in have similar requirements. So Is this a complaint where there is a mandatory reporting obligation that you need to take care of immediately? Is this a complaint that needs to be shared with law enforcement? Is there potential criminal implications? Is this a situation where, due to the severity and the nature of the complaint, that even though you've not completed your investigation, there's somebody who needs to be put on administrative leave? Generally, I recommend, if you need to do that, that you put the person on paid leave while the investigation is pending. And another thing to be thinking about right off the bat is this a repeat complaint? Is this a complaint about an employee or a parent about whom you've received complaints before? Conversely, is this a complaint by an employee who tends to complain a lot? If you're getting multiple complaints about the same person from different individuals, that tends to be a factor supporting the credibility of the complaint. If this is an employee who is a serial complainer, that may cause you to, have more questions or more skepticism about whether this is a good faith complaint and whether this is something that needs to be questioned. Step 2, you want to formally acknowledge receipt of the complaint. Just let the complainant know that you are taking this seriously. That goes a long way towards assuaging concerns. Sometimes you have a complainant that says, thanks, but I don't want this to be investigated. If the complaint is alleging a violation of law, then you really don't have a choice. Even if somebody says, I don't want you to investigate this complaint, if there's a potential legal violation, you want to go ahead and investigate that thoroughly. Your third preliminary step is to determine who should conduct the investigation. 2 questions to be thinking about here. The first is, are there any potential conflicts of interest? For example, does the complaint concern your HR director, who normally conducts these kinds of investigations? If so, you probably want to get somebody else involved. The second question is, do you want this investigation to be privileged? Generally speaking, if you've got somebody in HR or somebody else in the administration conducting your investigation, any materials that are gathered or created during that investigation will be discoverable if there's later litigation. Whereas if you have an attorney conducting the investigation, a lot of times we can help you take steps to protect the investigation under attorney-client privilege and or work product. So just a question to be thinking through there. And then you want to think about who's going to be interviewed, what order you want to conduct interviews. Very, very generally, I like to start with the complainant and then interview witnesses and then your respondent last. But there are certainly exceptions to that rule. And then last, you want to think about what policies and documents do I need to gather? And one thing that I would add there is, are there any devices that you need to collect? Is there a risk that evidence may be destroyed? Because you want to be thinking about making sure that evidence is to protect the integrity of the investigation. So in terms of conducting investigation interviews, I think for the most part, these bullet points here are pretty self-explanatory, but just to touch very quickly on a couple of them. Confidentiality, a lot of times witnesses or complainants are concerned about confidentiality. And what I tell clients is you want to avoid promising that you'll keep the investigation confidential because, there may be decision makers who need to know what's going on in the investigation. You may want to get guidance from your attorneys. So what I usually say is, it's ultimately the company's decision to decide what to do with this information, but we will do our best to keep it confidential. We will not be sharing this information with anyone who does not have a business need to know. And we ask that you keep it confidential as well. The other point I wanted to touch on this slide is You want to, if you're a public school district, there may be due process implications here as well. You want to be sure that you're providing notice of what the allegations are to the alleged wrongdoer, and generally you want to provide that information in writing. You also want to think about how you're going to do your interviews. For example, in the age of Zoom, we do a lot more Zoom interviews. I personally am very much in favor of doing interviews in person where possible, particularly if I think somebody's going to give me a hard time or may not be truthful with me, or if it's somebody that I think is very nervous and it will help me establish a rapport to be in person. So that's just something to make sure that you're thinking about. Next, I want to talk very, very briefly about documentation in an internal investigation. If you take one thing away from this portion of the presentation, let it be that you want to document, document, document. And Daniel will be saying the same thing when it comes to performance management and termination. So that is a theme that you'll hear us talk about several times today. But you want to be sure that you are keeping track of each of the steps that you're taking. Who have you interviewed? What documents have you collected? And also, and this is where I see schools and other clients as well tend to not be as great about documenting, is as you are, taking interview notes, things like that, be sure to include your thoughts about whether someone is credible or not, and if not, why not? So, for example, do you have a couple of witnesses who their stories match too perfectly? Does it seem like they have coordinated ahead of time? Do you have a witness who seems nervous and is acting shifty when you're asking about a particular topic? Do you have documents that contradict what the witness is saying? So in terms of assessing credibility, it's important to be documenting that as well. You want to make sure that you are keeping track of not only the documents that you're gathering, but also the documents that you're trying to gather. So for example, somebody tells you, oh, well, I was texting with my manager about this the other day. You want to try to get those text messages. If they say, well, gee, I don't have the text messages, you want to make a note of that because that can be relevant to credibility as well. And then finally, use technology where appropriate to help you gather documentation. Everybody thinks about, emails, everybody thinks about text messages, instant messages, but, you may also want to think about, for example, computer forensics are a tool that we use almost daily in investigations. When people do things on their company devices, there's usually a record of that. Another tool that can often come in handy is surveillance video footage. Badge swipes can be handy, particularly if you are, trying to pin down whether somebody was in a particular place at a particular time. So just be thinking about, are there other technologies that can help in this situation to substantiate or not substantiate the allegations? In terms of assessing the results of your investigation, it helps me, and what I recommend is to lay out each allegation. For example, somebody might be saying, my principal harassed me, and also, a parent harassed me and a coworker harassed me. So you want to be sure that you are laying out each allegation so you know what you need to respond to. I also recommend categorizing what facts are not in dispute and what facts are in dispute. And in terms of the facts that are in dispute, what is the evidence on sort of each side of the story? Are there documents that will help support one side of the story or the other? Or is this a situation where it really is just he said, she said, and there's, no surveillance footage, there's no emails, are there credibility factors that weigh in favor of one side or the other on a disputed fact? Generally speaking, you want to have an investigation report that lays out what the findings are, states whether each allegation is substantiated or not substantiated, and summarizes the basis for the conclusions. That is typically going to be Exhibit A if there's ever any litigation arising from an investigation. And having a thorough investigative report is super helpful to be able to show that the school conducted a diligent investigation. The thing that courts focus on is not whether you're right, although that is important. You want to be right, but the most important thing is to make sure that your investigation is diligent and is reasonable. And last, you want to think through what discipline, if any, is warranted. Obviously, in the public school context, there may be due process considerations here. There may be a hearing requirement. But the other point I wanted to make about that is everybody thinks about discipline for the alleged wrongdoer. But what I also often see is that you may have employees who have been untruthful in an investigation. You may have employees who refuse to cooperate. There may also be others who are not employees. So, for example, is there a parent who's been harassing employees? So are there other areas where you need to think about whether discipline or some other remedial action is warranted? And you want to make sure that your policies provide for discipline for those who don't cooperate in investigations or act in bad faith or provide false information. It's helpful to be able to point that out because that is something that comes up pretty frequently. And just very quickly, in terms of how this tends to play out in litigation, like I said before, the most important thing is to make sure that the process is reasonable. It's not about having, a perfect record. It's not about having 100% accuracy every time because, a lot of times we are dealing with incomplete facts. But you just want to make sure that your investigation is reasonable, that you're following any policies that you have regarding investigations, and that you're treating similarly situated employees the same. Because treating similarly situated employees differently is also often a factor that may weigh in favor of a finding of discrimination. So with that, I'll turn it over to Daniel to talk more about that discipline and performance management.
Hey, good afternoon or good morning, depending on where you are calling from and whether or not you observe daylight savings time. I am Daniel Masakayan. I will be talking about performance management and termination best practices. I was thinking about, as Heidi was talking about, how we've the 4 topics here, and like Heidi was saying, a lot of these topics will tie together, and we'll try to kind of tie them all together at the end here. But kind of in a timeline for the issues that we see from schools, typically there's an issue. We investigate that issue. We figure out the discipline, if any, that we're going to apply in that situation. And then if it comes to it, we decide whether or not we need to come to a termination decision. So I'll talk about the time where the issue first starts and we start recognizing the issue, what to do when we're trying to consider those issues, and if it does come to it, how to approach a termination. So we've talked about internal investigations. Now we're going to talk about performance management. And so when we talk about performance management, I think the term performance management is kind of a overall kind of a title for dealing with employee discipline, performance issues. There's a situation with your employee where you're trying to figure out what are the next steps I should take in terms of, do I investigate this? Is this an employee that's right for termination? What kind of discipline do I impose in this situation? We'll talk about some high-level best practices for those kinds of decisions you're going to be making. We'll try our best to make them most relevant for our K-12 kind of attendees here. But also know that even if you're not a K-12 entity, and even if you're, whether or not you're public or private, these concepts, like my colleague Farnaz mentioned at the beginning, will apply across the board to employers, all employers. So some best practices to think about are, you need to be able to, when you're making this a decision on how to discipline, make sure that they understand your employees why you're making discipline. And this is the first thing you should do when you're figuring out whether or not to make a decision, is to look at your policies and see what your policies say. Because your employees have to know what policies, if any, that they're violating. And they should be on notice of what those policies say and where they can find them. So it's always a good idea to refer to your board policies if you're a public school entity, your handbook, and any other policies you have at school. Hopefully, all those policies, the handbook, board policies, and any other policies you have are consistent, and there's no kind of differences there, because if there's inconsistencies, the issue becomes, which policies do we have to follow? The key here is that just because something is in your policy doesn't necessarily mean it's law. The law is what we need to ultimately follow, and typically, hopefully, your policies are in conformity with the law. So as I was saying, it's always a good idea to start with the policies. Consider the law too. If you're trying to figure out what to do in terms of whether or not to discipline, try to find out, does the law require you to discipline or to take some kind of action in the situation? For example, a lot of our K-12 attendees, the law in your jurisdiction may require you to take certain actions if there's a situation involving misconduct, sexual misconduct, child abuse. In Virginia, for example, there are laws about things that employers must do, or the K-12 entities must do. There's an allegation of sexual misconduct or child abuse. One of the bullets here, as you see in front of you, is the idea of discipline being progressive. So we put that here because a lot of policies, and you should, again, doubly check your policy and see what it says about how to impose discipline for your entity. But a lot of policies have a progressive disciplinary kind of steps 1 through 5 about how we're supposed to handle discipline. We typically talk about, a verbal warning first, all the way up to, at the end, termination. It's really important to look at what your progressive discipline policy says, because we want to be able to also, in case it's an extraordinary situation, jump, let's say, from steps 1 to 4, coming to, if it's a really a big incident or really some kind of incident that requires immediate action to be taken, we want to give the employer or the K-12 entity discretion to be able to make that decision. And so it's really important that you give yourself in your policy language that allows you to make that decision. What's also really important too is that your discipline has to be consistent. So Heidi and I get situations all the time about how do we handle this situation? And let's call it situation X. Situation X is not in your policy, right? So you've got great policies at your schools, you've got great board policies about a number of different issues, but situation X is just not necessarily covered in your policy. What often happens is that we get a call and say, what do we do now? I mean, this is not covered in our policy. Should we just let it slide? The answer is, if it's not in your policy, one, it's not to say that we can't add it to the policy later, but more importantly, you have to make sure you're treating all situations similarly. So if there's a situation X happens, next we should document that happens, potentially talk to your attorney about whether or not we should have a policy about that. But more importantly, next time situation X happens, right, for another teacher or another kind of employee, make sure you're applying the same exact approach to situation X that you did previously. Because as Heidi was alluding to, every single time we make a decision that's inconsistent, it increases the legal risk for educational institution because of the idea or potential claims of discrimination or kind of unequal application of policies. I'll try to quickly go through some of these other bullets. Make sure the discipline is timely. You shouldn't delay. If there's a situation that requires discipline and you feel like this is a situation we should discuss how to whether or not we should discipline this employee, it's defensible if we do the discipline immediately. It's problematic if we wait a while before we impose any kind of discipline, because the delayed action could be subject to question. And the last bullet here, and I should have put it in bold and maybe just put it maybe repeat it a couple of times. You need to make sure that discipline is documented. This is going to play into my next section about termination, but the number one thing that gives me most heartburn with coming to discipline or termination decisions is coming to a decision, especially a termination decision, and there's no documentation in the personnel file, or no kind of for performance or anything in the personnel file that ultimately lead to a termination decision. So we're talking about performance management now, but that will become relevant later when we talk about termination. Okay, so let's talk about some steps for effective discipline. Step one, I alluded to earlier, is make sure that your employees understand what their policies are. Make sure they know where they can find those policies. Again, sometimes, at least for our public school clients, there's a handbook, there are policies of the school, for example, or the division, and there's school board policies. Make sure those are all consistent, and make sure the employees know where they can find them, whether or not it's on some kind of portal or whether or not we give the handbook out to employees. Make sure they know what the policies are. It's also a really good idea to have your employees sign acknowledgments that they've received these. That way they know that the policies are applicable to them. And two, if you ultimately decide to make a change to those policies, make sure that it's a good policy to make them acknowledge the policies again and track that they've acknowledged those policies. Also, as to step one, training, any training that you can give about your policies, whether or not it's the beginning of the school year or whenever there's a policy change, it's very important that your employees understand what those policies are, especially if you're trying to make a disciplinary decision based on those policies. Step two, again, this is a little backwards, but gathering the facts. This goes to what Heidi was talking about in terms of conducting an investigation. It's really important that when you're coming to a discipline, it's not to say that every single time you have to do a full-throated investigation, but you need to be able to understand that we need to be able to gather the facts, know what the facts are before you impose some kind of disciplinary decision. You can land yourself in hot water if you come to a disciplinary decision and you haven't gathered the facts or haven't done any due diligence about understanding the circumstances surrounding an incident involving one of your teachers. Step three involves making a decision on appropriate discipline. It's really important to, Heidi was mentioning, treat all employees that engage in similar conduct the same. So again, in a novel situation about situation X, or if you handle a situation one way previously, make sure to handle the situation consistently the next time. Step four is review, and this is a nod to all of my HR practitioners here. It's really good to keep HR in the loop about decisions, whether or not, whatever level of the school you're at, keep HR in the loop, because oftentimes HR is the ones who will have to deal with all the administrative work involving the discipline, and also it's good that they are aware of where if supervisors are thinking about making certain decisions. Keeping HR in the loop also allows consistency in how we apply discipline, making sure that, because HR will know what the policies are, making sure that we're applying them consistently and also in accordance with our own policy. And step five is act. Again, make sure, like Heidi said, to document. Okay, so these are some suggestions on, you'll have to apply your own policy and see what it says about progressive discipline, for example. But what's really important is that you figure out how you want to approach the situation in accordance with your policies, obviously. One example would be, for example, a verbal discussion, talking with the employee about, what is the concern? What is the policy that we think is being violated? And how does that not align with our expectation of them as an employee? And every single time we talk with them, we should document the fact that you've talked with them, keeping them in their personnel record. That way, the next HR practitioner that's working on this case, or that anyone who also opens the personnel file, understands when the employee was talked to about a certain situation. If it comes to it, you can also consider a performance improvement plan. This is another way of, let's say you don't want to take a drastic action such as a suspension or a termination. This is a way to collaborate with your employees and say, look, we understand here, we want to help you to better do your job. And this is another good thing to consider as a K-12 entity, because of obviously everyone dealing with personnel shortages, right? And not taking the drastic action to terminate right away, especially if we can rehabilitate an individual to make sure that they're able to stay in the classroom but also still work on their professional development. A PIP is a good way to help them develop, kind of re-steer them in the direction that we can keep them, but also allow them to grow as an employee. But some quick pointers for PIPs. You should make sure that the PIP itself states the issue. Highlight the policies that you feel like are being violated. Make sure that they have notice of prior conversations you've had with them in terms of, in the PIP, highlighting times we've talked to you about X situation, so that this PIP documents how we expect you to grow in the future. And then also make sure you're highlighting consequences for failure of the PIP. And I'll talk about that here in the next slide, because a lot of times the PIP becomes, if not Exhibit 1, Exhibit 2 in some kind of litigation down the road, because a PIP needs to be very clear about what we expect for our employees. The expectation should be black and white, as in it should be very clear how they can hit certain metrics in terms of their performance, how they can comply with policies, and how they can, again, grow as an employee, so that we don't have to come to the decision to terminate. But what's very helpful for our clients is to use flexible language, and this is across the board, not just for K-12, but for any kind of employer. Using flexible language in a PIP, approximately subject to further disciplinary action, gives the employer the ability to respond, especially if the employee later on continues to violate their PIP or continues to violate a policy that actually made them subject to PIP in the first place. So giving the employer discretion to take certain actions when their PIP is violated, or if the employee continues to falter in their performance, is good policy when we're putting together PIPs. And again, send a copy to HR. Keeping HR in the loop is always a good idea, because it allows policy to be handled consistently across the board. I'm going to quickly talk about special considerations for schools. I will talk a little bit about Virginia specific issues, but this applies across the board whether or not you're in Virginia, because in schools, there are often, especially in public schools, there are often state grievance procedures that you have to consider. When we're making a disciplinary decision, depending on the decision and the discipline being applied, the employee may be able to grieve that decision. It depends on several factors. For example, whether or not the employee is a licensed or unlicensed individual. But regardless, schools should consider whether or not there are due process implications of the discipline being applied in that situation. The second is internal policies versus handbooks versus state policies and school board policies. Again, making sure that all those are consistent is good policy, because it allows us, and by us, I mean school divisions or schools, educational institutions, to make sure that we are applying clear rules to our employees and that they understand what those rules are. A third consideration that I wanted to note, and because I know that several of you are dealing with these issues, is teacher shortages, employee shortages, difficulties in hire. It's difficult across the board to hire and retain teachers in all kinds of educational institutions. So we should be prepared for it if we make a decision about discipline and it does go up to termination. be prepared of how we're going to respond to that, how we're going to fill that position, and how whether or not the classroom has the ability to continue with their lesson plans, for example. The last two ones are administrative leave versus suspension. This is a weird caveat, and this is specific to Virginia folks here. Administrative leave and suspension are different terms, but they're often used interchangeably. We should be very careful of those, and I'm talking specifically to public school entities here, because there are due process implications for suspension, specific to the suspension, that you have to consider. Whether or not use the magic words of administrative leave is a separate issue, but we do need to know that if you put someone on administrative leave and it's effectively the same as suspension, there could be due process issues. And finally, Heidi was mentioning mandatory reporter obligations. If you are making decisions about whether or not to discipline someone, you might need to determine whether or not you also need to report that to a state education institution. All right, I will quickly run through, just for timing purposes, termination. So we've gotten to the point now, we figured out what discipline we're going to impose. Now we've decided that termination is our best option. At the end of the day, if you've documented and followed the rules in connection with how to best handle personnel management, again, discipline, you've documented, you've documented, you've made clear, you've clearly laid out what the policies are, it sets up for a smoother termination, because how you handle personnel management are the building blocks for a successful termination. And what I mean by that is, if you handle personnel management correctly, termination becomes there's less legal risk when you come to the termination decision. So terminations, I won't read all of this, but the keys here are that terminations have to be based on legal criteria, right? Legal objective criteria, and that they should be ideally based on prior issues that are supported by documentation. Again, I understand sometimes there are situations that require immediate termination, especially in situations involving sexual misconduct or anything involving a child, in terms of specifically sexual misconduct involving a child, and that might be required under state law. But again, ideally, run of the mill, we should make sure that termination decisions are documented prior. Here are some considerations that schools should consider. We're going to circulate this PowerPoint, and you'll be able to look at key questions you should consider. The reason we laid these out are, depending on how you answer these questions, it helps determine the level of legal risk for your entity. For example, was the employee aware of the consequences of their act? If the answer is no, there's a higher legal risk in terms of a termination decision. Did the school pursue a full and fair investigation of the misconduct? The answer is no. Again, there's higher legal risk. And one thing I wanted to note from this slide is the second to last bullet says, can we prove the employee is guilty? This is a really interesting question, and we get this a lot of times in terms of how our clients conduct investigations. The employer has the obligation to make a termination decision based on their reasonable belief. So if it turns out after investigation, you find out that after the termination decision, for example, that the information you're relying on was actually not true, so long as at the point that you made a termination decision, you were basing your termination decision on a reasonable belief, there's support under the law that an employer is able to do that. But again, you should conduct that investigation to make sure that you are basing your termination decision on reasonable belief. I've highlighted some of these earlier, but it's really important that that schools are prepared for the termination itself, prepared for the transition, prepared for the implications for the classroom. Who's going to be filling in the teacher if we do make the termination decision? How are you going to communicate that to the parents that will ask about termination? And that's something I'm going to talk about in my last slide, because schools are unique in that they're often small communities, and teachers and parents and administrators are often working together and talking together. And it's a tight-knit community. So when there is a termination, many people know about it and affects several people. So schools should be prepared on how they're going to communicate that, and also who is going to be able to communicate that with parents. One key too, and I'll talk about it in my next slide, is when we make a termination decision, we should try to it immediately after the termination. It's a situation ripe for defamation. So we should encourage employees not to be gossiping or talking about the termination after a decision's made. Very quickly, in terms of, I'm just looking at the slides here, very quickly in terms of how to make the termination communication, we have to consider all the logistics, and I'm sure all of you have dealt with terminations, but consider the logistics of it. When you're actually sitting down and talking with the employee, you're not there for a debate. You're there to communicate the termination decision. It's not supposed to be a back and forth dialogue. In fact, we discourage our clients from getting into back and forth dialogue, because during the termination decision, what you say will often be used directly in litigation. And you should have a list of talking points when you walk into the room about why the person's being terminated. Because if you end up deviating from that list, so let's say there's reason A is the reason for termination. And let's say I go into the room, I give them the termination paperwork, and I say, well, reason A is the reason on your termination letter, but we also considered B, C, and D. What ends up happening is that B, C, and D being mentioned in the termination meeting is evidence of pretext, which means it could be used as evidence of pretext, which is inconsistent reasoning for a termination. And what an individual could claim is that the inconsistent reasoning is rooted in some kind of discrimination. So again, you should walk in, make sure you're prepared, make sure the right people are in the room too, as in we typically advise at least 2 people, one of them typically in HR and one as a witness. Okay, and lastly, special considerations for schools before I pass it off to Heidi. Again, consider the laws binding your institution about termination procedures. I'm talking specifically now to public school entities. In Virginia, there are specific rules about how we have to handle terminations, how employees have to be given reasons for the termination, how they have to have certain meetings with certain individuals. Make sure that you're considering those processes when you're coming to a termination decision, especially because there are due process implications of failing to do that. Second, we've talked about the implications of teacher shortages now, whether or not you're able to fill that classroom, whether or not it's a long-term sub or some kind of person to fill the shoes of the teacher that's being terminated. Also consider your culture, whether or not you're a military school versus a other kind of school. You should consider whether or not you're applying your policies consistently. Consider whether or not your school would typically terminate for an incident like this in the past versus whether or not you're reacting in a single manner to a single individual and applying your policies inconsistently. Because again, inconsistent application of your policies can lead to claims of discrimination. And the last thing I should mention on this slide is the mandatory reporter obligations. Again, sometimes whether or not you are in discipline proceedings or whether or not you are in a termination stage, there are potential mandatory reporter obligations, not only to CPS, but to the state, depending on the reasons for termination. So make sure you reference your applicable law or contact your attorney to make sure, in addition to all the paperwork you have to do through termination, that there's not some kind of additional reporting you need to do. And with that, I'll pass it over to Heidi.
Thank you, Daniel. So I'm going to talk a little bit about the ADA and workplace accommodations. So this, for me, is probably the most common kind of question that I get as an employment lawyer is an employee who is requesting an accommodation, often an employee who is on leave for medical reasons. Sometimes it's a work-related injury, so there are workers' compensation law implications as well. So this is something that truly comes up on a daily basis, and it can get a little bit complicated. So very briefly, in terms of what the Americans with Disabilities Act covers, I think everybody here is probably aware that the ADA prohibits discrimination against qualified individuals with a disability. That means somebody who can perform the essential functions of his or her job with or without a reasonable accommodation. However, there's also a couple of other areas of coverage. The ADA also protects against discrimination against individuals who are regarded as having a disability. So think about it as the ADA is protecting against stereotyping disabled people. So if an employer chooses not to hire someone because, say the employer sees the person in an interview and thinks that perhaps they have a mental health problem, but they actually don't. If that decision was made on the basis that the person is regarded as having a disability, that can be a problem under the ADA. The ADA also provides some protections for individuals who are associated with those with a disability. So the way that this most often comes up, and it's not as common anymore, but for example, an employee's partner has some sort of genetic an employee's partner has some sort of contagious disease. This came up a lot with HIV back in the early 90s. And so the employer thinks, perhaps this employee shouldn't be near other people because of their partner's disability. Or you have an employee who has a family member who has a genetic disease. And so the employer says, well, gee, that person is probably going to send my health insurance costs through the roof. I don't think I'm going to hire them because they're likely to end up with this genetic disease. That is also prohibited discrimination under the ADA. However, for purposes of what we're talking about today, individuals who do not themselves have a disability are not entitled to reasonable accommodations. So, for example, if you have an employee who says, I'm missing lots of work because my kid has a disability and needs to go to doctor's appointments, that may be an FMLA issue, but it's not a reasonable accommodation issue under the ADA. To talk a little bit about who actually is considered a disabled individual under the ADA, the short answer is just about anyone who has a serious health condition. The definition of disability under the ADA is extremely broad, and it's a very low bar. The EEOC does not like when employers try to argue about whether someone's health condition is sufficiently serious to qualify as a disability under the ADA. A couple of ways that I see schools and other employers sometimes get tripped up on this. A disability can be covered by the ADA even if it's self-inflicted. So if you have an employee who smokes a pack a day and ends up with lung cancer, that employee is still potentially covered by the ADA and entitled to reasonable accommodations to be able to deal with the lung cancer. A question that has come up very often in the last couple of years is COVID-19 a covered disability? And unfortunately, the answer is it depends on the situation. But if you have an employee who is, for example, having long-term breathing problems, their asthma is materially worsened because of COVID-19, that probably is going to be considered a disability. If it was somebody who, had a fever for a day and then was back at work a few days later, perfectly fine, that's not going to be considered a disability under the ADA. There was a recent case that was interesting involving the University of Hawaii, where the employee tried to say, well, just because I'm unvaccinated, my employer is regarding me as disabled because I'm a higher risk for COVID-19 and related issues. The court said that doesn't count. That's too attenuated. You're not protected by the ADA. So the COVID-19 questions are continuing to come in, and just keep in mind that the bar is low for proving a disability, but it does depend on the individual situation. So if you have an employee who has met that low bar of showing that he or she has a disability under the ADA, then that employee is required to, then that employee is entitled to a reasonable accommodation. And so the big question here is what is considered reasonable? Reasonable accommodation does not mean that the employee can have whatever accommodation he or she wants. Reasonable accommodation does not mean that the employee gets to choose what the accommodation is that is provided. All the law requires is that employers provide an accommodation that is reasonable and will allow the employee to perform the essential functions of his or her job. A note on the essential functions piece of this. This is a phrase that we use and sort of throw around a lot in these kinds of situations. And make sure your job descriptions are up to date. Because when we're trying to argue, so-and-so couldn't perform the essential functions of his or her job, and then we look at the job description, and the job description doesn't say anything about what this person can or can't do. And so they're saying, well, it wasn't an essential function of my job. That can be difficult. And so from a perspective of proving what are the essential functions of the job that an employee needs to perform, everybody kind of tends to forget about job descriptions. They get drafted and then they go in a drawer and they never see the light of day again until you need to hire somebody new. I encourage you to be looking at those regularly and updating them, particularly as technology changes and the needs for a particular position change, because those job descriptions can be highly relevant when you are assessing accommodations and potential disability issues under the ADA. So it's the employee's responsibility to make you as the employer aware that he or she needs an accommodation. There's no magic language here. The employee doesn't have to say, excuse me, I would like to request a reasonable accommodation under the ADA. It can be something more along the lines of, gosh, I've really been having severe back pain, and my doctor thinks I need a standing desk. That is a request that is probably sufficient to trigger the employer's obligations to engage in an interactive process and hopefully arrive at a reasonable accommodation under the ADA. So what is the interactive process? So the interactive process is the back and forth between you as the school, as the employer, and the employee to determine what accommodations might work. Like I said before, it's not just a matter of the employee says, I want this, and then that's the end of the discussion. The employer has an obligation under the law to engage with the employee to figure out, first of all, what is the medical condition? Second of all, what limitations does that medical condition impose? And third of all, how does that medical condition impact your ability to perform the essential functions of your job? Most of the time, you are able to request medical documentation unless the need for the accommodation is totally obvious. Most of the time, the cases that we're dealing with, that's not true. So you do have a right to obtain medical documentation specifically related to the employee's claimed disability so that you can find out what accommodations might be workable. A lot of times we will either ask employees to provide the medical documentation. It's helpful if you have a form that sort of walks the doctor through what you need, or alternatively, you can ask the employee to sign a release that allows their healthcare provider to disclose information specifically related to the disability. You do want to keep that inquiry limited to the disability that is prompting the request. Because the ADA also prohibits unnecessary medical inquiries. So you don't want to say, give me all your medical records forever. You want to keep that request limited. And if an employee fails to engage in the interactive process, they say, I'm not telling you anymore about my medical condition. I just had one of these situations recently. I'm not going to tell you what's the matter. I'm not going to let you talk to my doctor. I'm not going to give you any medical documentation. I just need leave. That's not sufficient, and the employee is not entitled to a reasonable accommodation. That's really important. An employee who fails to engage in the interactive process, if you have somebody like in that situation, somebody who wasn't showing up to work and they said, it's because I have a medical condition and I can't work, that was not sufficient to trigger protection under the ADA, and that may be grounds for termination. So what does a reasonable accommodation look like? Again, this sort of depends on the circumstances, but some examples may be making facilities accessible. Everybody sees this with, sort of ramps, elevators, things like that. Acquisition or modification of equipment or devices. That's the, sort of standing desk scenario. The ones that are the most tricky are reassignment and unpaid leave. So if you take one thing away from this section, keep in mind that just because an employee has used up his or her FMLA leave does not mean that that employee can be terminated for failing to come to work. The ADA requires, in most cases, additional leave beyond what the FMLA requires as a reasonable accommodation. It varies depending on the state in terms of how much leave is considered a reasonable accommodation. It also depends on the job position. Is this somebody who is easily replaceable? Is this somebody whose job functions can easily be performed by somebody else? Unpaid leave beyond what the FMLA mandates is generally required by the ADA. I know we're almost out of time. So an accommodation is not considered reasonable if it would impose an undue hardship. So, for example, if you've got an assistant principal who's having to basically work two jobs because of an accommodation, that may be something that's unreasonable because it's too costly, it's too hard on other employees. A factor that's relevant here is your school's financial resources and your ability to provide coverage for the disabled employee. So again, the thing to keep in mind here is we may be able to say, that accommodation is too hard on the school. We can't provide it, and therefore it's unreasonable under the ADA. But that really depends on each specific circumstance. And then finally, what you're not required to do is eliminate an essential function of the job. So if an employee says, I can't drive, and they're a school bus driver, then you're not required to eliminate an essential function of the job in order to accommodate someone under the ADA. And the other thing that you're not required to do is to lower productivity standards. So, this is pretty straightforward in, for example, the sales context, things like that. In the school context, what this means is you don't have to excuse misconduct. You don't have to forgive people's failure to be able to perform material portions of their job just because of the ADA. All the ADA requires is a reasonable accommodation. So, for example, I had a school recently who had an employee who, was basically trying to say, my interactions with students, I acknowledge that they've been problematic, but it's because of mental health issues. And, that's not behavior that the school has to excuse. The ADA does allow you to terminate someone who can't perform the essential functions of their job, even with a reasonable accommodation. And I think that brings us to the end of the presentation. I know we flew through a lot of that, and there is plenty more that we could say about each of those topics. So if you have any questions, please feel free to reach out to me or Daniel at any point. Our contact information is here on the slide. And I don't think we have time for questions, but we will follow up with anyone who submitted questions in the Q&A box. We'll follow up with you individually. And if anybody would like to submit a question in the Q&A box, you're welcome to do so, and we'll follow up with you, or you can do so by email or just give us a call. And thank you all very much for coming today. The recording will also be available to everyone who registered for the webinar afterward. So thanks again.
Thank you.